There are some very odd things about the way the agencies interact with the judiciary, especially in the immigration area. First of all, litigating against the government has been severely limited by 8 U.S.C. Section 1252, which prevents courts from reviewing USCIS discretionary actions unless there is an issue of U.S. Constitution or interpretation of law. So it's way beyond Chevron deference. The Real ID Act tells the courts you cannot look at anything which has been committed to agency discretion. Some courts have taken a very dim view of this Real ID Act, this provision of the law. They have found exceptions and they have reached and reviewed these decisions anyway. Some of them have found certain areas of the law were not discretionary. Some others have found other ways of getting around these bars. So the law of a particular circuit must be looked at before you undertake a litigation against the government. Jurisdictional issues can be quite daunting. Our typical experience with litigating against the government has been once we file the case, first request from the government will be extension of time to answer. And of course, typically, you don't want to not agree to a reasonable amount of extra time because after all, you are dealing with the government. They have to get the files over and they have to look at matters, get a lawyer assigned. And thereafter, we get a typically with the answer or close, depending upon the rules of the federal court that you're in, local rules, you will get a summary judgment motion which includes some very, very detailed issues of jurisdiction as well as formal defects with the complaint. I'm talking about a 50, 60, 70 page, 80 page motion and brief. So once that hurdle is overcome, and if the case is not won on, see, typically these cases go before the government in actions of mandamus or some kind of a writ, quo warranto, certiorari, mostly mandamus actually, and some of them are in the habeas corpus posture. So most of these cases are decided on paper, not so much on testimony. But dealing with the government has its own very, very interesting approaches that you need to keep in mind. You see, when we file a mandamus against the government, what are we looking for? We are saying to the government that you owe us a duty to adjudicate. Typically, mandamuses are for either some delayed decision making or very poor decision making. Okay, so eventually, if it's a time issue, you could end up, if the government loses or settles, they will make every effort to deny the case. It's very unfortunate. My experience has been that at least in the last few years, government has gotten very aggressive about trying to deny cases that are litigated. And maybe I'm being unfair, but that's my experience. So bear this in mind when you take the government to court, because if you force them to adjudicate, they will send you a request for evidence or request for information which is so way out of normal that it'll really make you bleed. Keep this in mind. So it's not that easy to litigate with the government, especially where benefits are involved. If something clear-cut presents itself, sure, go for it. But this also requires counsel from somebody who knows the circuit, who understands immigration law and the power of the government. Doctrine of consular non-reviewability says that decisions made by U.S. consulates are not reviewable by courts. I think it's called Foreign Powers Act. Under Foreign Powers Act, consulates are immune from having courts review their decision to deny a visa, for example. Of course, courts have found this to be extremely unfair, especially where rights of a US citizen are involved. For example, if I'm a US citizen and I'm trying to sponsor my wife for something and the consulate declines the visa, I may have a way I can approach the court and get around the doctrine of consular non-reviewability. Bear in mind, when you deal with government decision making, there is no stare decisis. There is no value to precedent. Government can reopen anything at any time. So I was reading just a couple of weeks ago a case in which government gave a benefit and then 5 years later opened it and revoked it. And courts were understandably so quite upset, and the decision was actually quite strong. There were observations like deference is not due to a bureaucrat, referring to the government officer who was adjudicating the case. But there's no stare decisis in government decision making. I've attached a memorandum for your review from USCIS, which says very clearly that we can revisit the merits of each case de novo, even if it is merely an extension or an amendment of a previously approved case. Another very odd, and maybe I don't know enough about other agency practice, but I found this particular point to be very odd, that federal court decisions are not binding outside that court's jurisdiction. Most of these government agencies consider themselves to be national bodies. So if a court in Tennessee decides something against the government, if it is the federal court, the government is only bound to follow that decision if the case arises out of that federal court's jurisdiction. If it is a circuit court that gave the opinion, then the government is bound to follow that decision only in that circuit. Again, yesterday we had a very interesting case in which a benefit was denied, but when I reviewed the case, it was an Illinois case, and it struck me that the Seventh Circuit had actually put out a ruling which could help us in that benefit. So immediately we filed a motion to reopen based upon that Seventh Circuit ruling. So different circuits can have not only law of the circuit as it operates in the circuit, but even USCIS for its benefits could be looking to different criteria in that circuit. Bear this in mind as well.